Welcome back. Today we're looking at the separate defendants, who both subscribe to the same misguided legal fantasy. Each appearance is brief, but both serve as a preview of what's coming later this month. One case is set to return in early December, where we'll see whether reality finally catches up. For now, let's get into how this starts.
Your Honor, next we can take Aaron Thomas.
Okay.
And Your Honor, after speaking with Mr. Thomas, he was not comfortable with me signing the rights form on his behalf, and he would like to have an arraignment in person.
And that's fine. Can you hear us all right, Mr. Thomas?
Yes, sir.
All right, very good. This is 3A757954 and 3A757955. When can we arraign him in person, please, Carrie?
Your Honor, due to the holiday schedule, the earliest would be December 7th at 2:30.
Okay, Mr. Thomas, write down December 7 at 2:30 and confirm when you've done that.
Okay. 1 second here.
No problem.
Yeah, I got my phone stolen last night, so I gotta do it on my computer here.
Yeah, no problem. Just let me know when you got that in there.
All right.
Did you get it in there?
Not quite yet. I'm opening up.
Okay. Just let me know.
What you're watching here isn't confusion. It's avoidance dressed up as principle. Basic tasks suddenly become impossible when someone is committed to rejecting the system they're standing in. The irony is obvious. Someone who claims independence from government authority can't complete the simplest procedural step without help.
Thank you, sir. Okay, you said December 7th at 2:30, correct?
Right.
All right, yeah, I got you.
And it's here at the Bothell Municipal Court, Mr. Thomas.
Okay, thanks. All right, yeah, I got it down.
Thanks so much for writing that down. Keep that, don't erase that. That's your notice now. You got an actual notice, right?
Well, oh yeah, I mean, I have it on my computer here.
Fantastic. Thank you, sir.
Hey, I
All
hope
right.
you have a good day.
The court's found probable cause for the prosecution is charged, so subject to you and your lawyer readdressing this, you're to be here on time for all scheduled hearings, commit no criminal acts, don't drive until you have valid license and insurance in your pocket. Any questions about all that?
No, I wasn't driving though.
Good. Please don't unless you have license and insurance in your pocket.
I would
Right.
never drive. Yeah, I would never drive.
That's fantastic. Glad to hear it. Thank you, sir.
You're welcome.
All right. Next case.
Okay, cool. Have a good day.
You too.
That wraps up the first appearance. The next date is scheduled in person, but only for an initial procedural hearing. If history is any guide, future appearances will move right back to remote court. Nothing substantive has changed, just the setting. With that out of the way, let's move to the next courtroom.
Mr. Frank Michaud, who is present here on Zoom. Mr. Michaud, can you state your name for the record?
For the record, I am the beneficiary of the Frank Anthony Michaud Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee, ma'am.
HIs is a familiar tactic. Declaring the judge a trustee is an attempt to manufacture a conflict where none exists. It's not clever, it's not new, and it doesn't work. Courts have addressed this argument countless times, and the outcome is always the same. The case moves forward unaffected.
Mr. Mohammed.
Good morning, Your Honor.
Good morning. My apologies for interrupting your breakout, but I want to get some of the matters that are already on screen and ready cleared out. Mr.
Okay.
Sullivan and Mr. Moshood.
Ready?
Thank you. Today is a day and time set for the probable cause conference. How are we proceeding, Mr. Sullivan?
Judge, as I was saying earlier, Mr. Michaud has indicated that he'd like to represent himself. Hopefully, if it's acceptable to him, I can remain just sort of present for the proceedings in case he has any questions. My recommendation to him is that we demand all of the discovery in the case, We have paper discovery. I'm forwarding that to him, but we don't have any of the digital discovery. So we are requesting all of that. And then I'm also recommending to Mr. Michaud that we schedule the case for a preliminary exam. And I'm happy to be present for that as well.
Mr. Mohammed?
Yeah, Judge. So I don't believe we had an attorney on record, on file for this case, and that's probably why discovery wasn't sent over. Also, I believe we're missing some stuff as well, and we're in the process of getting them as well. If Mr. Sullivan's going to be the attorney moving forward, we'll send it to him. But if he's no longer going to be retained, then I don't know. I don't think it's useful to send it over to him. So if we can know who the attorney is moving forward, we'll send that discovery to that attorney.
Mr. Sullivan, are you formally making a request to withdraw from this case?
Judge, maybe my request is that we have an adjourned PCC for me to meet with Mr. Michaud and discuss this further, unless he'd like to make a decision just here and now. Perhaps one adjourned PCC and some additional time for Mr. Michaud and I to discuss this. We can come up with an arrangement where I'm at least receiving the discovery, on his behalf and trying to facilitate this for him. But I do want to respect his desires to represent himself.
And Judge, the people would have no objection to any adjournment. And if Mr. Sullivan is the attorney moving forward, please just send me an email letting me know, so that way I can make sure digital is sent to you.
Notice what happens when trained professionals are allowed to speak without interruption. Progress. Counsel outlines a workable path forward, one grounded in actual law. But once the defendant insists on taking control, the momentum disappears. Strategy gives way to noise, and the opportunity evaporates.
Mr. Michaud, were you able to hear Mr. Sullivan just now?
Yes, ma'am. I heard everything that was said.
And was that a reasonable way to proceed at this time? I'm sorry.
Oh, no, I still stand as being the beneficiary of the estate and point you as trustee, and demand that this alleged debt, is discharged from my account, from my exemption account.
Silence was doing more for the defense than any of these claims ever could. There is no special account. There is no hidden exemption. Repeating internet myths doesn't create rights. If those ideas had value, they'd hold up outside of comment sections. They'd on single quotes.
As I sent over copies of my birth certificate, as well as an affidavit. I don't know if you received it, but it's been sent certified mail. And that is me standing as making this special appearance today. And with the challenge of the jurisdiction, since I have not really been fully told, or I really don't understand really the allegations or the nature and causes of this allegations.
At this point, the problem isn't legal complexity. It's basic comprehension. When someone can't follow direct explanations given in plain language, the court can't fix that. Procedure only works if the participant is willing to engage with it honestly.
On my estate.
Sir, I'll interrupt you just for a moment. In as much as you've indicated that you don't understand or have not been fully apprised of the nature of the allegations, we will adjourn this matter over for 3 weeks. That adjourned PCC date will be
December 20th at 8:45 with Judge Oakley.
the adjourned PCC date will be December 20th, 2023 at 8:45 a.m. That's in person in courtroom number 2 with Chief Judge Brian Oakley. And between now and then, Mr. Sullivan, you have the opportunity to speak with your client, bring him up to date on the status of these matters and explanation of the charges against him. And if you want to, at that time, have a conversation with Judge Oakley about how you be proceeding or not proceeding as counsel, that would be the time to do it. Is there anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Sullivan?
Judge, I apologize for the inconvenience, but I am in a sentencing that morning of the 20th. I don't know if does the court have availability like later in the morning. I could make it work late morning on the 20th or in the afternoon on the 20th.
10:45.
That'd be much better. Thank you very much.
Thank you. 10:45 on December 20th. That concludes this matter. You're free to go. You have a good afternoon.
That brings us to the end of today's appearances. There are 2 more dates on the calendar later this month, including one before a judge who has already shown zero tolerance for this type of argument. If these defendants expect a different outcome, they're misreading the situation badly.
It's under the barcode, though. This is what you signed up to do. You're a public servant.
Unless you are a price on a can of beans, we don't need a barcode.
If you found this breakdown useful, you know what to do. More courtroom analysis is on the way, and none of it relies on theatrics or myths. Thanks for watching. This is Judge Talks.